I've met a lot of people who we've successfully referred to the courts, and they tell these stories and they're so harrowing in terms of what happened to them, but they always thank us and say how grateful they are that we believed in them and believed in their case. There is 100% sign up to our core purpose of uncovering miscarriages of justice. And the feeling in the Commission on a day when we can make a referral is palpable because everybody is so excited about it. If you went out to the man in the street and said, who do you think deserves more Treasury money? Right now, they're going to say National Health Service. We will be right at the bottom of the list because the average man on the street will say, and I hear it, there's no smoke without fire. They must have done something. And that just isn't an appropriate premise to have. But, you know, we're not popular among the average member of the public unless they've had a family member who've suffered a miscarriage of justice. And then you go right to the top of the list. Background and history is pretty varied. Started out studying law at Queen Mary College and have been in and around the law ever since I graduated, but have also had various commercial roles. So I'm an experienced chairman, non-executive director, senior independent director, but have also been involved with bodies such as Queen's Counsel Selection Panel, recommending barristers for Silk to the Lord Chancellor, also with the Bar Council, the PCC, which is Professional Conduct and Complaints. I am a lay judge at the Employment Appeal Tribunal and have been so for 20 years. And my most recent job in the criminal justice system is chairing the Criminal Cases Review Commission. Mm-hmm. And as of last week, I have been made chairman of the Public Chairs Forum, which is the body that represents chairs across the whole range of ALBs and public bodies.
Goodness, so plenty of experience and expertise. Helen, we asked you to talk to us because of the CCRC's involvement in the post office scandal, but we may go a bit beyond and into other things. But tell us first of all about what the Commission does and the powers that it has, please.
Yes, very happy to do that. We have wide-ranging powers. There are a lot of myths about what we do and how we do it, but we are an arm's length body from the government, so we are completely independent. We have commission status, which means I need at least 11 or 12 commissioners to have oversight of the organisation. And what we do is receive applications from individuals who either believe that their sentence was wrong or they were wrongly convicted of a crime. So it could be sentence needs to be shorter, perhaps because they did more time on remand and that wasn't taken into account. Or it can be, I didn't do it in the first place, and I want you to look at the evidence that's there. We were set up under the Criminal Appeals Act in 1995. So we've been going for 25 years next year. So we'll have our 25th anniversary. We do not charge applicants for coming to us. And a myth in the system is it costs £3,000 just to put an application in. It doesn't cost a penny. Where it might cost is if the applicant has got legal representation and they don't have legal aid. And as we know, legal aid certificates are not as freely granted as they used to be. So only about 10% of our applicants have legal representation. Some of them have legal aid, some of them don't.
And the cost then is they have to pay for their lawyers, essentially.
Yes. So you mentioned the post office earlier. A number of those individuals who have been pursuing their cases did have to pay for lawyers or went without representation. And that can be a considerable problem. So we have given evidence at the Westminster Commission. We've given evidence to various Justice Select Committees about the fact we think there should be more legal aid available to support applicants through this process. So they will apply to us. They can apply in writing, or they can apply via our easy read form, which we've produced, which is on the website. And once the application comes in, we will then do what's known as triage it. And that means several people take a look at it. We decide whether we need to ask for more information. And if we do need to ask for more information, we will then send out a request under Section 17 of our statute asking for that disclosure.
Who might you be asking that?
We can be asking the police. We can be asking organisations. We can be asking the representatives. So there can be a whole range of people that we can say we really need this information in order to enable us to go further. Mm-hmm. Now, the Westminster Commission, when they reported recently, said we should have an even stronger statutory power, which says that information must be provided within a defined timeline. We can't change that ourselves. That's a statutory change, but we have said we agree with that suggestion. We can also go to private individuals under another section of our statute, Section 18, to require them to give us information as well. So we will collect the information, and the case is then allocated to a case review manager. And the case review manager will work through all of the information and will prepare for either a submission to go to what's known as an NDM, which is a nominated decision maker, or if it's a more complex case, to go to a committee of 3 commissioners. And so the case review manager does all of the work, comes to the committee. The committee will either say, no, we still need more information from here, or will sign off on what's known as a PSOR, which is a provisional statement of reasons, which then goes back out. If the case is pretty clear cut, we don't have to do a PSOR. We might go straight to a statement of reasons, which goes back to the applicant to say why we are or are not taking their case further. And if we are taking it further, we have to have a reasonable possibility, so we need new evidence and a reasonable possibility that the case will be overturned. So if that happens, that then gets sent back to the Court of Appeal. And the Court of Appeal typically agree with us in about 75% of our referrals. So that tends to suggest to us we've got the referral numbers about right. But one of the issues with referrals is we're basically people's last chance saloon almost when they come to us. So there are an awful lot of cases that we just do not have any new information, and therefore we can't refer. So by definition, we are disappointing probably about 98% of applicants that come to us.
So can I assume from what you've said that somebody has to have made inquiries already about there's another witness, this witness is probably going to say this, and come to you with that? You can't do that work. You have to already have been helped a little bit. Would that be right?
Typically, people will come and say, this is the new evidence. It might be new DNA evidence. It might be a new witness that's come forward. It might be that a witness has been discredited in other cases, which has happened in some of the cases we've referred recently. So if we can find that new evidence, then we can do something with it. If we can't, then we have to write out and say no. Some applicants come back to us on several occasions, usually saying, we think we found something else, we think we found something else.
And you don't mind that? That doesn't matter?
No, because a miscarriage of justice is a miscarriage of justice, and that is our sole purpose, is to uncover miscarriages of justice. So I have to say, in all the organisations I chair, and I do more work in CCRC than any other board I'm on. It's the only organisation where I can honestly say there is 100% sign up to our core purpose of uncovering miscarriages of justice. And the feeling in the Commission on a day when we can make a referral is palpable, because everybody is so excited about it.
Wonderful. And would it be right to think that there are lawyers who have really, if you do have an opportunity to have a lawyer, and you're very lucky if you have legal aid, they can really set the scene for you if they do their work and they've got, some more evidence. Yeah.
And that really helps us, because it then comes in a very crisp format. If you're an individual, and we've seen it on one of your podcasts, if you're an individual that feels a sense of injustice, it really burns. And so you have a tendency to think you have to write chapter and verse, when in actual fact, we are looking for the kernels that say, these are the 2 or 3 things you need to address yourself to, because this is where the problem lies. So that can come to us through Innocence Project, who are doing it pro bono, and other organisations, and also from lawyers who specialise in work of this nature. But again, if it's legally aided, it is not well paid. And there are people leaving the criminal bar in droves, which is a cause of concern for us.
It is.
So if you send somebody back the preliminary opinion,
yes,
can you get into a kind of dialogue with them as they kind of like tighten up the information they provided? Because clearly they may not have realised what they have to say. I mean, as you say, you want the kernel, you want the core of their information rather than a essay about it. So do people respond by saying, this is the point? You get into some degree of dialogue there?
Yes, they will come back and say, I thought the point I was making is this. Did you address yourself to that? Is their broad question. It might be worded in lots of different ways. And we will make sure that we've covered that off. If we haven't, we'll take another look at it, which is why we send the provisional one out. If we have taken a look at it, we will go back and we'll say this was taken into account, but it's not new evidence.
And how do you do the same issues about statements of truth and evidence given under oath? Or
yes,
how do you know the evidence is kosher?
We will certainly take a look at that and see if A, the witness was a credible witness, and B, if the submission was a cogent submission. If we have any doubts about that, we will do background checks to see whether they have any criminal convictions themselves, where they might even have been on the day they say they observed something. So we've got really wide-ranging powers and can do all of that.
And who would do that investigating? Sorry, I'm interrupting you.
Sorry, no, that's fine. We will instruct external experts. We also have within our team investigators who can do that. Many of them have been former police officers themselves, so they know how to question and challenge. And we'll go out and interview witnesses. If we have a concern, we will go and interview them, and they have to consent to that interview.
So you are, where's your funding coming from, Helen?
It comes from the Treasury, from the Ministry of Justice. So they will provide us, we put a budget submission in every year. We don't always get everything we ask for, but we do put a budget submission in, which is fully reasoned as to why we want that. There has been publicity recently in that over the years, our funding has been cut. And my predecessor said that for every 10p he used to have, by the time he left 3 years ago, he only had 4p. Now, yes, the budgets had been cut, but the reality is we have become a much more efficient organisation. When we first started, we inherited a huge number of cases that used to go in through a government department. So there was a massive backlog when we first started. And everything came in huge boxes of paper and that kind of thing. It now comes in for the most part, except for when it's coming from prisons, it comes in electronically. And so it's easier to search for and mine the data. So we have created efficiencies. We've got a really good case management system that enables us to know where we need to go and enables our commissioners to know which pathway to decision the case review managers have been taking when they come to them, but it's nonetheless a commissioner's decision that's made at the end of the day, which decides whether it's referred or not. And one other area I was going to mention is there's a category known as no appeals cases. Now, 40% of the applications that come to us each year have not gone through the full appeal route.
Right.
So unless it comes from a magistrate's court where there was a guilty plea, which happened with a number of the post office cases, we just have to go back and say, no, you need to exhaust your rights through the appellate courts. So we will refer that back. So there's quite a high percentage that we just write back and say, you can't come to us just yet because you've not exhausted your rights. If they did plead guilty at the magistrate's court and they therefore don't have a route to appeal, we then investigate it. And if we find what are known as exceptional circumstances, then we can still refer. And that happened with a couple of the post office cases.
So when the post office cases started to, you started to realise that you were going to get all these cases, that couldn't have been in your budgeting, I wouldn't imagine, because there's a phenomenal number on its way to you if they haven't already arrived.
Yeah, no, it wasn't in our budgeting. So we asked for more money and we got it.
Oh, right.
Yeah, so we did get it, which is very helpful. An awful lot of them, we are saying go direct to the Court of Appeal. If you didn't plead guilty in a magistrate's court, you do not have to come to us. Just go straight away to the Court of Appeal under your own steam. So, that means we don't have to review those cases. But those where they did plead guilty, then we will look for exceptional circumstances. And if we find those, such as a systemic issue, like the Horizon computer system, then we will deal with it. And we referred the cases basically on an abuse of process, an abuse of privilege argument, in that the post office were victim, investigator and prosecutor. So our referral to the Court of Appeal was very much based on the fact you can't be all three. And therefore that needed looking at. We also wrote to the Justice Select Committee about that because we do have a duty to basically highlight systemic issues in the criminal justice system. And they agreed with us and have made recommendations for policy to avoid that kind of thing happening again in what are essentially private prosecutions. It doesn't mean you can't do a private prosecution because the post office is allowed to do it by its statute, but it does mean that there should be a sort of oversight of that to see whether there's any systemic problems coming into play.
One of the issues that crops up in the post office cases, but we're hearing about from other people, is the failure to disclose evidence, and sometimes the court not requiring evidence to be disclosed. In other words, because there are delays or objections raised, the court is not, as we understand it, is not pressuring the prosecution to produce the evidence that the defence is asking for. And we've heard about that. I mean, we hear about it in the context of managerialism in the courts. That is the pressure to kind of fit into timetables, to meet expectations of budgets and scheduling and so on. But it seems to have been rife in the post office cases where very often there didn't seem to be any evidence presented apart from something was wrong with the computer readout, therefore they stole the money. And that seems to be a systemic problem way outside just the post office issues.
Yeah. Yes. I mean, somebody said to me recently, how do you know if you've got full disclosure? And the answer is we ask for full disclosure and we have the powers to ask for it, but we have no sanctions if we don't get full disclosure. And it's only by, as we start to investigate the cases, and thousands and thousands of hours go into investigating cases, and particularly did into investigating the post office cases. And we had to keep going back because we'd look at things and think there is a gap in the information here. So that took us quite a while in the initial phases when the cases first started coming through to us, pre the High Court case about the Horizon computer system. And, you know, we just kept going back, but we weren't at that point getting full disclosure. I have to say we do now, and we're confident we do because we've worked very closely with the Post Office to make sure that's happening. But it takes a lot of work from my team to liaise with people in the appropriate legal departments in the Post Office to make sure we're getting all of that data.
So they're much more cooperative than they were?
Yes, yeah, absolutely, yeah.
But we were talking to Professor Richard Moorhead from Exeter, who was commenting that he thought that the Post Office, the sub-postmasters are a more sympathetic bunch than your average criminal, and that they probably would be treated more sympathetically. But this business of courts refusing to press for disclosure or hurrying the case along, and therefore disclosure not happening, might be actually very common in many criminal cases. I don't know.
We've seen it in the Liam Allen case, haven't we?
Well, Liam Allen, it was a very close
that was late disclosure. Those tend to be few and far between. I mean, it was awful what happened with Liam, and he is now very much a spokesperson for justice and spends a great deal of time working that way. He comes along to our stakeholder forum, so we know Liam. And he's passionate about it, not surprisingly, because of what happened to him. But it's the classic. You cannot legislate for a corrupt police officer. No. Sometimes it happens, but once it's discovered, that is then a reason why we might refer something back to the Court of Appeal. You cannot legislate for people who don't disclose. At the moment, we ask for disclosure. We have wide-ranging powers for it, but we have no sanctions. So, you know, that may be something that has to come in. I think the courts generally rely on the advocates to deal fairly with each other and exchange the information. And it's within their oath when they become solicitors or barristers or QCs that they will be transparent and they will provide appropriate disclosure. So it's reasonable for a judge to say, if you are being told you've had everything, unless you can prove otherwise to us, then we have to assume that you have.
That's very difficult, isn't it?
It is.
Because nobody has the power to, as you say, nobody can enforce it.
No. Well, you can be struck off if you get caught out not disclosing.
Well, what we seem to be hearing quite often is that the most expensive legal firms specialize, in fact, in helping corporations, for example, to steer as close to the wind as they can in avoiding that kind of, outcome. And that's what they get paid for. That's their reason for being so expensive, because they are so good at getting you so close to the wind.
That was something said by Paul Pascoe to us for the HBOS Reading fraud.
Okay, yes. Yeah. And, you know, in one of my broader roles, which is around board effectiveness and board governance, my view of that would be that's inappropriate behaviour from the organisation, and the board should be cited on that because it's a reputational risk, as it was for HBOS, as it has been for a number of other firms. So you should know what legal cases are in the pipeline and might cause you a problem. And then appropriate questions should be asked of the relevant executives as to what are we doing about this? Are we certain we are doing the right things?
We're hearing as well, and I mean, I know you have so much expertise, it will be interesting to hear, Helen, your response. Are there certain board directors who have a kind of attitude which people pick up throughout the whole organisation of don't tell me anything bad? You know, I don't want to know.
I don't think that's the case now. Has it been the case in the past? Very possibly. Once upon a time, you went onto a board of directors, having had an illustrious career as an executive, and you went on the board because you played golf with the chairman, who was a chum, and he said, "Oh, I need someone like you." And typically, boards then were looking for former CEOs and former CFOs. So that has broadened now because the remit of non-executive directors is so wide. It's into social responsibility, it's into reputational risk, it's into cyber, it's into employee engagement, just a whole range of things that didn't used to be within the domain of the boards. So now non-exec directors know that if they don't come along and ask the right questions and do their due diligence on the paperwork and satisfy themselves that they're getting the right information, it can ruin a perfectly good career. And
right.
Some of them then will never end up on a board of directors again. If they get disbarred, they'll be off for 7 years. A lot of people will voluntarily, if they realise there's been an issue, say, I will not apply for a board for 7 years because I don't ever want to state I had to step down. And that happened in the charity, the children's charity.
Oh, Oxfam.
Oxfam was one, but no, I'm thinking of the one.
Oh, Kids Company.
That's right, yes, yeah. And all of those non-exec directors, trustees, have really good careers. But because they didn't know what was going on and clearly hadn't asked all the right questions, they voluntarily said, we will not stand for boards for the next 7 years. But, that was really unfortunate because, you've got people like Alan Yentob, you've got people from AstraZeneca, really good professional backgrounds, and their careers were just ruined. So nowadays, and I certainly in my time of evaluating boards, I've been evaluating boards for 30 years, but it's even more apparent now that non-executive directors take their roles really seriously. And actually, the risk-reward ratio is not good because they're not paid hugely. And to my mind, that has an impact on social mobility. So you still will get a certain demographic of people serving on boards, which needs looking at, more and more, not just, we've had the Parker Review, we've had the Hampton Alexander Review, all of those kinds of things, but it does need to be broadened out to make those roles accessible to slightly younger people. I mean, I've got a portfolio, I can afford to do that because I'm 63. So that's fine. But do I know enough about cyber? Yes, I know the key questions to ask around cyber risk. But younger people would be far more switched on around that, and boards need to widen the net.
But what is going to happen with the post office sub postmasters? Because some of them are going off to the appeals court because they haven't appealed, but some of them have presumably landed with you. Yes, and you're reviewing them.
Yeah, we are. Yes, we've got more cases in. We're working on those. We're reviewing them. We don't refer everything because for some, when you look at them on their specific facts, there's nothing in there that says this was about the computer system. So we don't refer everything, because one question of us at one stage by the press was, so you're just going to refer everything through now? We said, no, we can't do that because we have to look at each individual case on its merits. So it's still a lot of work, but I've got a good dedicated team working on it who know what they're looking for and are working really, really hard.
And presumably you're discovering problems. I mean, obviously Fraser identified a whole lot of problems in his judgment or his judgments, but you may be clarifying them, going further than he needed to, just for the purpose of his trials.
Yes, absolutely. And if it's a systemic issue, we'll feed it into the Justice Select Committee to say this needs looking at, like we did about disclosure, and they responded. So we will do that.
Do you have any general kind of issues that you could tell us about, or is that too difficult?
That's too difficult to do. I mean, we've got great statutory powers, but we've also got great statutory limitations in terms of what we can disclose. So we work very hard at being as transparent as we possibly can and because the post office cases are, a group of cases, even though they've got different facts in them, it's very difficult for me to comment because I'm not allowed to comment on specific cases. And that category is a specific category.
With the post office board, Helen, are you able to, we are definitely picking up from what we have heard that there was a board that didn't want to hear very much if it didn't suit them. Are you able at all to comment on the board or not really at the post office?
It was a shared risk. So you also have to ask the question, what did the Fujitsu board know?
Yeah. Because
it was their system. I think there's two boards there that it's worthy of saying who knew what, and if they didn't, why didn't they know?
Finally, you were going to, or you did have a look, I know because you said you had looked at Nicola Arch's interview. I don't know if you've got any comments that you would like to make on that, Helen, her circumstances.
Well, she spoke from the heart. We've heard a number of stories similar to Nicola's. That doesn't make it any better for Nicola, but people's lives were destroyed by this. People are still suffering from stress and mental health issues because of it, and trust issues. And people's reputations in their communities were destroyed. And she talked about, when she went to a supermarket and what happened to her. And sadly, and you'll have seen it from all of the people that were interviewed by the press when we had the mass quashing of the last tranche of cases we put in, these stories were not unusual. And some people have died since being prosecuted and never, ever known of their innocence. And some people's family members have died and not then known that their relative was exonerated. So it's really, really heartbreaking and has been the biggest single miscarriage of justice that we have ever had in this country. So, and we're ahead of other countries because CCRC was the very first Criminal Cases Review Commission to be formed. So we give advice to new ones. So we've given advice in Norway, in Scotland, in New Zealand, and now in Canada about how best to set up these kinds of organisations to support people who believe they've suffered a miscarriage. And one of the issues we find when we're looking for more funding is, given all the challenges the Treasury have now, and they have given us more money, I'll caveat it with that. If you went out to the man in the street and said, who do you think deserves more Treasury money? Right now, they're going to say National Health Service. We will be right at the bottom of the list because the average man on the street will say, and I hear it, there's no smoke without fire. They must have done something. And that just isn't an appropriate premise to have. But, we're not popular among the average member of the public unless they've had a family member who've suffered a miscarriage of justice. and then you go right to the top of the list. And I've met a lot of people who we've successfully referred to the courts, and they tell these stories and they're so harrowing in terms of what happened to them, but they always thank us and say how grateful they are that we believed in them and believed in their case. Now, that's an issue for us in the sense that we cannot say we believe. We can say there's a reasonable possibility that there may be something here, and then the court has to do that. That doesn't happen in Norway. They can actually change and decide to quash the case there and then. We can't do that under our statute.
Are you hoping that will change?
I don't think it will change, to be honest. And it does need to go back through the courts. And the courts are very good with us in terms of listing. If we refer somebody back, they will make sure they go onto the court list as soon as is practicable, which is important.
Well, we think it's a really pressing issue, this one of public understanding of the risks of injustice and the difficulty people have in combating it when it strikes them. But of course, it's a once in a lifetime experience for those who do experience it, and it's quite a rare experience. You hope so. It's kind of rare experience for the general population. So it does, as you say, fall to the bottom of the list of priorities. It's not in there. It's not in your face.
No,
but it's crucially important when it happens.
Yeah. And as I said at the outset, there's still an awful lot of people don't understand who we are and what we do. So, having interviews like this where I can talk openly about who we are and what we do and why people should come to us is really, really important, because even some criminal barristers don't know we exist.